My Lord, permission, this is a case, my Lord, where the Noida authority, my Lord, has enclosed my land and possession.
It is already kept on 26.
For the last 3 days, my Lord, what is happening? Matter is coming but not being taken up. Now the next date is 26/11. My humble request would be, my Lord, kindly if this case can be somewhat upward in the list so that it can be heard, my Lord.
You can have on board.
Please, my Lord, I'm deeply obliged.
My Lord, praying any date, my Lord.
It is already there on 2nd of January. Reopening. Not to be deleted.
Obliged.
Yeah, this is that FTP matter. We had actually moved our representation before the Honorable Chief Justice. This is being listed pursuant to that minutes. If the Lordships can minutes give a date.
It's an admitted matter or
Well, it's a regular matter. Because in the letter that we had submitted, we had clearly mentioned it's a regular matter, but because of the fact that your Lordships had heard 1/3 of it. So we disclosed all of that. Otherwise, it would have normally, without approval, it would have not come in the mentioning list because even earlier, a regular matter doesn't come in the mentioning list. We understand that there must have been some approval that is.
it's an offshoot of that other matter.
It's a different change in law claim, but for the same impact. If the Lordships can, because what your Lordships had done is, these matters the Lordships had adjourned, standardized, saying we'll decide that, then we'll take this up. If the Lordships can, probably set it down on a date because there is considerable financial impact on account of these changes.
Live it in January.
It's possible, my lords, otherwise.
This side we have kept so many matters now. January
101 can't come.
I'll give a date in January.
This next part is stay laws in this matter, laws from April laws. Feelings are complete laws. I am ready to pay laws as per the imputed order laws. May I have it next week laws. So the industry is closed from last 2012 laws. I am only seeking the electricity.
2012, it's 23 matter.
Lordship, please.
How are you saying 2012?
No, because I am saying the genesis, the origin, the factory, my factory I have purchased on an auction in 2012 laws. I have applied for a electricity connection. The department is saying you pay the earlier dues. So that was the dispute in the before the High Court law. There is a scheme. Under the scheme, I have to pay that amount. There is a consent order.
Okay.
Just mentioned, the Lordships have listed that open correctional institutions, open prisons matter on Monday. I just want to circulate the most way Lordships can have a look at it. Some directives in past. One part of the matter, Lordships are already closed so far as legal aid prisoners is concerned. The other, I'm just circulating the notes where the Lordship have a copy of it.
This means we have already cleared that.
These on the open.
The
other
part by Lared was already.
Yes, that's why I said. So this part, I just thought I'll circulate submissions in advance. Great.
Item 1 was very quick, my lords. Very peculiar. In the predicate offence, I am not in the FIR, not in the charge sheet. Prosecution complaint in the ED has been filed. Now, the co-accused.
I think Justice Sundaresh has passed some order in a similar matter.
The co-accused. This is a different person. And I am accused of 3 crores. That person was given bail is 8 crores.
Policy is not followed here. Even if you are not in the predicate offence, as long as the predicate offence is there and laundering is there, you can be.
No, I'm not on jurisdiction. I'm saying something else. I'm not on that thing that your Lordships can't at all do it. It's possible. I'm on something totally different. No, kindly allow. I am something. I am on something more interesting. That person. But why it is this is an unusual case is not only I am not in the predicate, I am not the prosecution complaint has been filed now. There is no point of arrest now. But more interestingly, the co-accused released was accused of 8 crore plus laundering. I am accused.
Upper middleman.
3 crore.
3 crores is your commission.
No, that's the allegation. Well, they found in another allegation.
And father only received it.
Well, another allegation is, another additional allegation is 1.5 crores returned before the FIR. Another non-cooperation is given. Your Lordship has given a judgment 3 days ago. Non-cooperation is another major grounds given. Because it requires notice first.
Notice returnable. 2 weeks.
Very good. Earliest, 2 weeks alright. No actual date Your Lordship is.
Serve it on the
Right.
standing council.
The only problem is they come after 2 weeks and they say we want more time. So
Liberty to serve.
we'll give a letter to them that this date is there, please file something if you want. Lordship will say liberty to file if they want to, because otherwise they take time again.
Liberty to serve the
Okay.
respondent. They have a standing council or central agency.
Central agency.
Mr. Maroria appears, Maroria.
Normally Mr. Marodia is there. But I will give it to the central agency. But the Lordship is standing up.
Liberty to serve the central agency.
Obliged.
Very please, Your Lordship. My Lord, in item number 2, the petitioner is a poor tribal woman, my Lord, whose house of 30 years have been demolished. And not only her house, there were 100 tribal people, my Lord, without any notice, without any advance.
No, but you are a basic, what are the basic prayer in the petition?
My Lord, may I read the prayer clause in my writ petition, my Lord? I am not, there were 2 prayers, my Lord. One was for my daughter, which was disposed of because the daughter came and said that she wants to stay with her husband, Ali's husband. The second prayer, my Lord, primarily also, my Lord, in all prayer A, B, C before High Court, it is not that I have only prayed for my daughter's custody, my Lord. I had also prayed for the against the illegal demolition and my livestock, which was taken away by the Surat Municipal Corporation officials. Without
How can you mix so many causes of action in one matter?
only 2 issues were there, my Lord. Only 2 issues were there.
You are seeking daughter's custody. Then in the same matter of action against the municipal corporation.
No, I'm not seeking action. Lord, may I just read prayer clause at page 179, Lord? It is just 2 pages I'll read, Lord, and then I'll read you, Lord. Page 179 is my prayer before Honorable High Court. And it is not that I am seeking to exercise habeas corpus jurisdiction only, Lord. I am also seeking to exercise parents patriae jurisdiction, Lord, which have been recognized by this Honorable Court in Jalil Kattu judgment, Your Lordship is available, Lord. Squaw animals, Lord. Lord, page 179. The prayer V says, Your Lordship may be pleased to grant a writ of habeas corpus and any other appropriate writ order or direction by directing respondent but so and so to produce corpus Shahana before this Honorable Court, and further the Honorable Court may be pleased to set herself free from illegal confinement of police known place resident and give the custody of corpus to the petitioner. Then thereafter, Lord, as a mother of animals, bird, cow, buffalo, etc., also corpus, therefore, custody of all the animals, etc., be handed over to the petitioner, Lord. And Lord, next page, Lord, page prayer E, my Lord.
No, those are all then during pendency only.
No, my Lord. I'm so sorry. Even in the second is the pendency issue, my Lord. First, absolute prayer made for custody of the animals, my Lord. Second, also in the last 4 lines, Your Lordship will see, and also produce animals.
Thank you. Dismiss.
My Lord, may I just read one last page, Lord, page 43.
Thank you.
Your Lordship, this is the case, my Lord, which is covered by Your Lordship's recent demolition judgment, my Lord. Without any notice, without any.
It has nothing to do with that demolition judgment.
My Lord, may I just read page 43, 4 lines?
Dismiss with cost 45.
No, my Lord, I'm so sorry. I'm not pressed. Deeply aware.
14 years, I'm not suited on 2 grounds. The delay part I'll explain. I could not come to India because of COVID and I have said so on affidavit. Please see, and the second, 21. My lords, in this case, Your Lordship, I just want to show 2 dates. My lords, yes.
Your habeas corpus is 4 years delayed. Your proceeding in US is 1 year after the departure, 20th September 20 and 21st September 21.
No, my lords, my US petition was filed within 10 days. It took me 1 year to get the order. 30th 9, 2020, I filed the US court proceedings, sir.
You say you didn't
September,
subpoena because of misunderstanding.
and sir, she served in 25th February. That's a built-in fact. Her lawyer, all of them are served on email, sir. The only fact is 21st September, sir. I get the order from the US court today. I'm not even allowed. And my lords, police constables are out the family court with bodyguards. I have to meet my daughter. Now, my lords, I'll tell you. 2.5 years, admittedly, she stayed there, and we stayed in the US for 14 years. The marriage was performed in the US. Now, she files under HMA, that herself she files for amendment. And my lords, the High Court at page 47 has committed a serious blunder, my lords. Please see the finding which will saying that an OCI card holder without a passport can stay in India, directly contrary to the circular of the Home Ministry. Please see page 47 for a minute. Her stay in India is invalid, my lords. Please see page 47 for a minute. That finding rendered by the division bench is wrong, contrary to the statute, my lords, and the rules. Page 47, your lordship has that. As far as the arguments of the petitioner that her passport is expired, page 47, my lords.
Of the handwritten pages.
No, my lords, the impugn order.
Para 36.
Para 30.
Yeah, para 36. Para 36. As far as the arguments of the petitioner that her passport has expired, we have noticed that L is an OCI holder, and on that basis she is entitled to stay in India. Once she has attained majority, will be entitled to choose whether she would give her US citizenship. Though OCI holder is not recognized as citizen, but definitely it's a form of permanent residency available to people of Indian origin, and holder of OCI card entitled to multiple entry in India and permitted time of being complete. OCI card holder is entitled to continue stay lifelong. Fellows, please see. The circular of the Home Ministry.
Possibility of mediation.
I can never say no to mediation. But parties tried in the High Court. See, he wants to use this as a tool. He requested him apply for renewal of the passport. He is refusing to issue. Therefore, the intention is very clear that he wants to put the gun on my head and seek his relief from the court. Now, this is really terrible.
We are not inclined to entertain.
No, but I just
The present.
Can I just say something? In this case, can I just show two mails? I am on the flight and she says, go back. I said, I will get a COVID certificate. I do 10 days.
We are not inclined to entertain the present petition. However, we clarified that nothing observed in the impugn order could be considered by any of the courts if proceedings are initiated under the guardianship.
No, must not say guardianship. There are no guardianship proceedings.
If they are initiated, we are
They
saying.
not say guardianship. That will hurt me more. I'll tell you. She has 500 HMA because the marriage was not never in India.
But in America, you already got a divorce. I read somewhere.
First order.
That is the he should have suspended also.
We have clarified that nothing observed in the impugn order shall be considered in any of the proceedings if initiated or already pending between the parties.
Yeah, my lordship, the present appeal has been filed on two main grounds. First is the consent of Attorney and Solicitor General of India for the contempt petition. And second is the criminal defamation of my reputation. My lordship, neither Attorney General or Solicitor General have reverted to my 9 requests and 12 emails to give their consent. And the Honorable Registrar.
Thank you, dismissed. How can we go into all the disputed questions? Who is entitled, who is not entitled? Either file a suit or file a criminal complaint.
That's what I wanted that we.
If it is impersonation.
Yes, because the disbursement was pursuant to your lordship's order.
Yes, and our order was pursuant to the order passed by the earlier bench, another bench.
Yes, my lord. So therefore, we are constrained, my lords, to approach your lordship with that for that liberty, my lord, that if there is any remedy available to us, we may initiate the same, my lord, because the state government is not deciding our representation 1 year before pursuant to your lordship.
No, state government, that authority says, since the matter is arising out of the High Court's order.
That's the difficulty, my lord.
Sorry, we clarify that.
May I just, one thing I'll add.
In the present petition, the petitioner.
My learned friend was given the liberty. The person who was given that liberty by your lordship was somebody else.
You don't want to go into all.
Well, lordship given liberty then.
The claim of the petitioner is that though the amount as directed to be paid as per the orders of this court, did it?
Was it 17 January 2020?
17 January 2020.
17th of January 2023. was to be received by the petitioner, the same has been fraudulently withdrawn by some other person also. We do not wish to go into the dispute question as to who is entitled to withdraw the amount which was payable to Messrs. Wangcham Associates.
Vangam Associates.
So,
My lord, it was paid. May I clarify one thing, sir?
Vangam
It has been
Associates.
paid to Vangam directly. We have not received.
We are not going into that aspect.
Yeah, very good.
Wangam so and so Associate Khansa.
Payment has been made.
How many times you will say that?
That
How
is
many times you are?
That is his problem.
That
He
is
says-
probably, he says that, no, you are not, you are an ex-MLA, you are using your clout with the government.
Two of you came together and changed him. That is,
Let it proceed.
If you want, we will observe all that.
Your lordship, remember that better than I do.
No, we will observe that he is claiming that you are an ex-MLA and therefore using your political clout, you are now sitting able.
Your lordship, let it be, whatever.
Yeah. So we have to clarify that. We are not, in the order dated 17th of January 2023, we have only considered with regard to the entitlement of Wangchak Associates Khansa and not considered as to who representing the said entity is entitled to withdraw the amount. The parties avail of any of the remedy for raising the said grievance or order dated 17th of January 2023 would not come in the way.
Obliged. Grateful to your lordship.
My lords.
The power of attorney.
My lords, I must point out at the outset that a similar petition came up before my lords, which involved interpretation of a judgment passed by Honorable Justice Williams. So my lords may observe that diary number, so that I'll just pass on the orders. My lords can include the diary number of my that matter in this order.
Please. Lordship, the contender is in contempt of the order dated 8/1/2024, your lordship, of this honorable court, your lordship.
They are fixed it from 1196.
1186, your lordship.
1180, you are entitled to from 1186.
Yes, and they are giving us for till from 1196.
That's what was
Yes.
given.
Petitioner is given is that though the petitioner is entitled to protection from 1186, the decision has been erroneously done from 1196. Issue notice.
Obliged, your lordship.
Unless specifically ordered, the presence of the respondents is dispensed with.
Obliged.
You are in the.
No, my lord, he has completed his MBBS. My lord, though I have something to speak on marriage, my lord, I will not say anything. My lord, I am just requesting, my lord, if. Sorry, yes, is there.
There's nothing in the merit.
My lord, I am just requesting to protect his admission.
He is protecting all bogus tribals in.
Problem is, last week we had the same matter.
Same matter.
Just so, what happened to that seat which should have gone to the really deserving?
My lord, what happens is this, my lord, the committee takes a longer time. Now, my lord, he completes his education in 2019 and committee invalidates in 2020.
That is why FCA Baliram came and said that don't be sympathetic. But now we are faced with this
My
situation.
lord, what happens is, my lord, Madhuri Patil, which initiates everything. My lord, that itself.
I had taken a different view in Bombay.
Yes, yes.
But now, in view of the Supreme Court judgment, that view is no longer a.
My lord, that FCI's judgment is stricto sensu, my lord, is in regard to the employment. But so far as these students are concerned, there is no specific paragraph in the FCI judgment.
Notice on limited relationships.
Returnable 4 weeks. Till then, they shall be stayed to the MP on order on a condition that the petitioner shall not hereinafter claim any of the benefits of belonging to children right.
I'm sure.
Mr. Mendra, next time get that judgment which I delivered in Nagpur.
Yes, ma'am.
May please, my lords.
Just find out some equity.
May please, my lords.
Is there?
May please, my lords.
One a day. Thank you.
Item 9, 9.1, 31 and 31.1, my lords. There are 4 matters listed today.
Why did you list all the 4 today? You know, we had told you on the last day at least 1 every day.
The 4 times a week I have to go. I've been 60 times. This was not the intent of the Lordship's order. I'm a respectable person. 60.
You should not be returnable 2 weeks.
MA we have served them. Anyway, let's give me a shortest notice.
2 weeks, you said.
Next week, if possible, I can only request.
There are no.
This man is a respectable. He has to go. 60 times he has gone.
No, we'll clarify it, but next week there will be,
2 weeks, very well, 2 weeks. 1 week I can't write a
next week we have so many Constitution Day function and all that, so we'll be reading. So the copy today only.
Sir, it's a MA because the Lordship's order, we are saying relax the condition. It's already served on them, but they will never come on advance copy and all that. Lordship knows that. That's the.
And on the next day they will sick time.
So that the Lordship will make clear what's the time in this. It's a.
Notice
the same ED has given no objection for all other accused. Your Lordship had similar conditions for other accused in some cases. They've given no objection.
No, we clarify that.
Harassment only.
On the next day we will clarify it. I would know how many investigation.
I will say 2 things, Miller. 1970.
Before you begin.
Yes, ma'am.
If you argue this matter.
Yes, ma'am.
You are arguing it at the risk of exemplary cost.
Kindly see the connected matter.
My brother says that not less than 5 lakhs.
Your own matter last week, same claim, Rajendra Singh judgment, same thing, same matter.
1975, then the act was not there.
Asked by Mr. Varinder Kumar Sharma.
Notice has been issued.
Watched by the law department on video.
Kindly see in other matter, kindly see the order, notice has been issued. Notice has been issued, Miller. Kindly see, Miller. No, kindly see the order, Miller, of this court. In connected matter,
Maybe.
no, kindly see the order.
You take somebody's land, build a road,
No,
and then you don't want to pay anything.
Is right, but Miller, kindly see. I am not able to digest. Then notice has been issued.
Maybe if some other bench has erroneously issued notice,
You have to
that doesn't bind us.
get it dismissed so that your digestion is normal then.
Kindly, Miller, I am not able to understand. Otherwise, they will say what you have done, Miller. Kindly.
You will call out all those matters.
No, kindly see, Miller. Kindly see. That is what Miller I am pointing out. Kindly see. This is surprise for me also, Miller. Kindly see. And matters are coming up because there are so many link road, Miller. Prior to 83, Miller. Land Act came into 1983, Miller.
Now you show this order to the other benches.
My cases are over, Miller, today. Only 5 were allotted. My lord have dismissed 5 matter. And other matter are going there, Miller. What I can do? Yesterday I came to know about this, Miller.
We have come across several matters wherein state of Himachal Pradesh has challenged the order passed by the division bench of the Himachal Pradesh, Himachal Pradesh, thereby directing compensation to be paid to the respondents. The High Court, by an elaborate judgment, has considered the petitioners that approached this court. The petitioners had the writ petitioners had approached the High Court with a grievance that though their lands were, the possession of their lands were taken for construction of road, they were not paid compensation. By the impugn order, the High Court has held that the state cannot take possession of a citizen's land without paying compensation. Therefore, paragraph. So, a right to property is no more a fundamental right. It is still a constitutional right. A state cannot be permitted to acquire a citizen's land without paying compensation. Therefore, paragraph. In these circumstances, we would have been justified in dismissing the petition with exemplary costs. Also, however, we simply dismiss the matter.
Let it be simple dismissal. Let it be simply dismissed.
No. Now, the other respondents will show this order to the other
I
bench.
have only 5 matter, my matter is over.
No. We will pass this order so that the other respondents can show this order to the other bench.
Please, my lords. My lords, this is arising out of a complaint, contempt case, my lords. I have been wronged on 3 grounds, my lords.
So you should be grateful to the High Court that though your contempt petition was not tenable, still some equitable order has been passed in your favor.
That is exactly what I am on, my lords. What they say is,
You don't want to pay the current dues.
Please,
You don't want to pay the current dues.
No, my lords.
50% ordered.
Please,
You
my lords.
already filed an order 39 2A there.
Please, my lords.
Contempt, they relegate
We have
you to
complained.
39 2A. There is a direction that current dues will be paid here.
Please, my lords.
That is normal.
My lords, may
Your
really appreciate.
firstly, your contempt itself was not tenable in view of order 39 2A.
My
Yes,
lords,
fine.
my lords, in contempt case, such an observation could not come in. They have
We
disconnected.
will set aside this order.
Ah.
We'll say that the contempt jurisdiction,
Please, my lords.
the High Court was not justified in giving such a relief to the contempt petition.
My lords,
This is something like, in Marathi we call it, in the, "Aa bain mujhe maar."
Please, my lords. I can very well see what is falling from my lords. My lords may have para 4 here. What they say is, however, the learned counsel for the respondent has pointed out that as many as 27 electricity bills have been sent to the petitioner, and over last 2 years, apart from 23 disconnections, notices have been sent, which is absolutely wrong. Let them place it on record, whether I have received it or not. My lords, these are things which are said in open air, they have been recorded in the order, and then my lords have the learned court has.
What do you want? Do you want a simplicity dismissal or
my lords,
a dismissal of the order?
My lords, in this particular case, had there been, may I show the list of dates? How they have proceeded?
Dismissal.
My lords, may just see, my lords. I have challenged.
The petitioner has challenged
Huh.
the order of the High Court.
My lords, on getting the notice.
So High Court finds that contempt petition was not tenable, has passed an equitable order in favor of the petitioner. Paragraph. We find that the High Court was not justified in passing an order in favor of the petitioner when it found that the contempt petition itself was not tenable.
My lords may not say that. My lords may.
Impugn order is therefore.
Just one thing, my lords. Just one thing. See the content of the department, my lords.
See your conduct. You file a contempt petition as well as.
Not triggering out from that, my lords. My lords, just see the.
How is contempt petition tenable?
I received a notice.
You please tell us how is your contempt petition tenable?
My lords, I'm just showing that. Just first, before that, my lords may come to list of dates. I receive a notice for disconnection. I approach the honorable court, learned district court, to get it set aside or get a stay in it. Before that,
In the meantime, if dues run, what happens? You tell me. It is all dated demand. You go at a particular stage. You go on 1st January.
Please, man.
The amount quantified is 10 lakhs.
That's what will happen. Even
Matter is decided down the line. How will they function utilities?
My lords, then again, my lords, please appreciate.
if this will continue, I pay this 50% amount, then again for next high pitched demands will be made in the high assessment that have been made in.
Dismissed. Dismissed.
You have remedies under the Act, no? We all know the Act 2003.
My lords, I totally get that, my lord, but see the vendor, what they are doing.
Thank you, Mr. Thank you very much.
My lords, after we issued a notice.
Dismissed with cost quantified.
Keep your.
Dismissed.
The petitioner has come for cancellation of bail. Bail has been granted to an accused who is an accused in murder of 4 persons and subsequently also. Subsequently, about after 2 months, another eyewitness was also killed in this case. So far as the reason given by the High Court is concerned, then the High Court has granted bail to this petitioner on the ground of parity, citing that 3 persons have been granted.
You are only against Sachin Ray. You are only against that Sachin Ray.
Right now, I filed against Satish Rai.
Satish Ray.
Satish Rai alias Bachara. Specific allegations are also against him. So, the High Court considering that 3 bail has been granted.
3 bails have been granted. According to you, 3 have also been rejected.
According to rejected. Two bail applications were rejected, and 3 accused persons were granted bail. This is the only reason given by the High Court. So far as.
Yes, well, I am not clear, my lord. No, in fact, there were, in fact, against them also there were 4 FIR lodged, my lord. They made an attempt to kill my wife, Satish Rai's wife, burnt alive, my lords. And on account of that, 2 FIR was lodged by the state and 1 FIR was lodged by the Sarpanch Ministers. Lord, they have not brought on record, Lord.
What happened in that matter? What happened in that FIR?
Lord, in fact, they went to the High Court for constitution of a SIT, and the High Court had constituted a SIT, and they are doing thorough investigation in all the matters, Lord.
They are not arrested.
No, they have not been arrested. And in fact, my lord, I have been given regular feedback.
Maybe brought on record, maybe said on affidavit.
Dismissed.
Much.
Lord, may I submit? This fact maybe because I haven't got such instructions.
No.
And moreover, my lord, section.
Maybe it's a discretionary order unless the discretion is exercised. Unless the discretion is exercised in a perverted manner, why should we interfere?
The only ground that has been given is.
The order is passed. Our order is passed in which month? You are asking me.
Yes. On 27th March 2000.
Where in which month?
27th March to March.
Where in which month?
We are in November. Thank you. Lord, but may I, with utmost respect, if I may say then.
Dismiss with the cost. 25 rupees.
Cost may not be imposed. The family members have been imposed.
When we say that it's a discretionary order, on one hand we say that the High Courts and the trial courts are not granting bails, and when they exercise the jurisdiction, we should interfere in that.
Saying that my lord will permit, then I will submit. Otherwise,
thank you.
Lords may condone the delay.
And dismiss it. Delay condoned, dismiss it.
The other man, what happened to the perjury against him?
No. Have you filed an appeal that the complainant?
He's got into trouble now.
My lords, actually there are multiple cases have been passed for perjury against the
Complainant.
Item 60 is a 2003 matter. 2003 matter. He's spent about 1 year to 4 months. Now, my lord, in those days the offence was differently worded, my lords. And second is at page 21, the father and the petitioner had a scuffle in the pond before.
What's the victim has deposed? Then her brother has also deposed.
Yes, both at page 21, both say that father had a scuffle with the petitioner, my lord.
Scuffle? Where has it come before the incident?
So that of course is.
No. You are saying.
I'll explain. Before, after the incident, there was no, they could not catch him, he ran away.
Grotesque
So
incident.
scuffle, the scope of scuffle was prior to the incident, because the other witnesses say that he ran away, and they chased, but he ran away.
Thanks to that Naushad,
No.
the girl is alive now.
Lord, what has Naushad has turned hostile, Lords.
That's what we all know.
But then he just could not do much, Lords, in the sense that in those days the definition was different.
You have been lucky to get only 4 years.
4 years was the punishment in those days.
Yes, but now it would have happened now.
Yes, today if I had done it, what I am submitting, Lord, is, Lord, you look at 20 years have passed. I am a full family man, Lord. That's what I am submitting, Lord.
Thank you.
Family man, Lord.
Yes.
Your Lordship, section 329, as per section 329, medical board was formed, and the medical board has given the statement that the accused is suffering from passivity and delusion of control and auditory hallucinations, which is the first symptom of schizophrenia. Now, after this report, simultaneously, jail report was also called, and the learned trial court has relied upon the jail report rather than the opinion of medical board. And the medical board further opinates. If my lord may please see annexure P9. My lord, the board states that they do not have further resources to ascertain the further situation, for which they have referred to a better facility. But rather than proceeding forward with ascertaining further with a better facility, they have decided to proceed further with the trial.
Clearly.
Lord, if Lord, please see.
No, thank you.
It very clearly states that they do not have.
See,
further
initial
resources.
stage of schizophrenia is nothing actually. The ultimate stage is catatonia.
I get it, Lord. But they have not. If
If you apply this initial stage, I don't want to say something from the bench. Most of us are schizophrenic.
Sir, I am the perfect husband. I am both deaf and dumb. And it's my
Ideally.
ideal. This is a matter which ought to be sorted out.
Also, but what's working as I was.
Assistant at all. There's nothing.
She is a lab assistant.
That you are saying.
She is a lab assistant. She's driven me, my parents and me out of the house. She is staying with our daughter. So
You seem to have some income. You seem to be skilled at tailoring or something.
Not really, my lords. Your lordship probably have seen only the maintenance application, the divorce one also. There are two petitions before your lordships.
Yes, she was earlier married, but then within.
Yes, she was earlier married. I did not know till it came to the time of cross-examination in 2016. The High Court says that you condoned it because you went on living till 2014. I never knew that you had been married earlier and that the marriage itself was a nullity. I should have. This is something which had.
If under law, normal circumstances, long cohabitation itself is enough to pursue a marriage. Why should not maintenance be given?
Maintenance
Why
is one
necessary
part
for the
of
marriage?
Maintenance is one
No,
part.
how is that a defense in maintenance, Prime Minister?
I'm not taking it as a defense, my first objective is forget the maintenance, keep it aside for a moment. My first objective is I need to be free. I do not want to.
You should notice in order to explore the possibilities of mediation.
I'm informed that I was taken into custody for payment of maintenance because I could non-payment for the.
Please release now.
We'll make it open.
The father who's who has some kind of law practice.
Who?
His father, who has some kind of law practice, has had to try and get him out of jail. Okay. So,
With notice taken. Practicing where?
Ivani.
You want? Yes. This is PW1 and PW3.
But there is no motive, also the.
Eyewitness dot motive, eyewitness case. You sword set on the neck, see the injury.
Yes, at page 5.
They have, and the FIR is immediate.
But only one injury, my lord, and my lord, there is no premeditation, and your lordship may kindly see. The accused also sustained injury, my lord.
Is there any evidence with regard to scuffle or quarrel?
Yes, my lord. The accused himself has got injury, my lord.
No. Hey, whether any of the witnesses say that there was a fight or quarrel?
All the witnesses who have been examined, my lord, they are all interested because.
Not interested. Neighbors are not interested in witness. On the contrary, at times the relation with neighbors may be.
Not neighbors, my lord.
Who are neighbors? One is mother-in-law and one is wife.
And out of 20, my lord, out of 20 witnesses, all were given up.
Thank you.
It is to be dismissed in view of the earlier order.
Yes, thank you.
Finding in that order not to interfere with the findings of the earlier impugn order that continues. See, I just give it to the court.
It's a case where the High Court has completely not applied its mind. It's a case where 304B and 306. The High Court doesn't consider the state of investigation, doesn't even consider the seriousness of the charges. This is a case where a woman has died in the matrimonial house within 4 months. And there is evidence to the record that there is a causation and proximity link that has come from the subsequent complaints and the Panchnama and the spot memo that she was being subjected to continuous torture and harassment by the parents.
Indicate which you have filed.
Yes, Your Lordship.
Some kind of serious misunderstanding and but there is no
demand of dowry.
Understand, Your Lordship, what has happened is the bench, when rejecting the trial court, when rejecting the bail, has considered those WhatsApp messages from both sides. They do categorically say
we
that,
saw the messages
yes,
also.
Lordship, the fact that he says that she was feeling trapped and she wants to die because of the entrapment that's there. She's categorically stated that.
Correct, but
that's the approximate thing that we need at this point.
But what purpose would be served? Because the investigation must be complete now.
Lordship, charge is not being filed. They released him before even filing of charge sheet. Within 2 months, they released him. Such a serious offense where she died within 4 months. The High Court doesn't even consider what will happen with Right, Lordship.
4 weeks.
Right.
Just to permitted.
Grateful.
We have 3 submissions to make on merits, my lord. That's the submission.
Since that we done. But I can negligent running with somebody. This family.
Please, my lord.
Have to pay some compensation.
25,000 was ordered by the High Court.
25,000 is for somebody's life.
I can do that.
Very good. Leave to implicate the family member of the deceased. Within how much time we will carry out the amendment?
2 weeks, sir.
The amendment will be carried out within 2 weeks from today. Issue notice. Returnable 4 weeks. I have deposited on 25,000.
Please, I have, indeed.
How much more you are willing to deposit?
I haven't sought those instructions, my lord.
You deposit one more life.
May I see, please?
For somebody's life.
Please.
Arguing counsel for the petition of on his legs, Lord, I am requesting to pass over.
Are there any similar matters? Similar matters have been dismissed.
Yes, my lord. And based on the order of this honorable.
Neeraj, they are saying that 3620 is overruled by the full bench.
No, but that is what really happened. That if your lordship will see the.
There's no discussion at all in the impugned order, only on this perjury and.
We are just clarifying. Impugned order.
Anyway, he's not here. His arguing counsel is not here.
Very.
When?
May I have it, Lordship, after?
Password kar de fir.
Lordship, may I have it after a week augmentation? I'm requesting a week augmentation this matter.
Where is he?
He's on his left, Lordship.
We'll wait for some time. If he doesn't come, then we'll.
Yes,
he's
only difficult to
Your Lordships, sorry. Your Lordships, my LP has not been considered merit, Your Lordships.
Catch your breath.
The question before the High Court was, Your Lordship, whether the work charge establishment employees.
Wait for a minute.
Let pass it over.
Your Lordship, I'll continue.
At the end of the module,
Yes, please.
there are only 3-4 matters.
Amicus is there.
But now the report is that he has been permitted to appear through video conferencing.
Very well. We don't have a copy of the report, so.
You have not been permitted.
6 months, sir. What happened is, sir, we have registered an unnecessary just to have this available from really to.
No, but now you have been granted permission to appear through video conferencing.
What happened is, I need to tell you, sir, you have seen or you tell me that, I submitted the CD also.
You go through the report, madam.
I will, Your Lordship.
Yeah, the learned amicus is requested. The registry is directed to supply a copy of the report of the learned district judge to the learned amicus. The learned amicus to examine the same. Whatever.
Monday.
1 week.
Monday also it's okay.
Monday week then we'll have it.
Very well. I'm ready.
We are led by Mr. Basan. He's on his leg in code number 6. Your Lordship may allow Passover, take it up at the end of the board. If you may.
He'll be youngest as I.
In this case, I have moved this application for stay of conviction, but my lord, I know the limitations. My lord, my only request is my appeal be heard. It's 9 years now, my lord, it's pending before.
The learned counsel for the petitioner does not praise for does not praise the petition. However, the request for expeditious disposal of the appeal. I have taken into consideration that the appeal is pending for last 9 years. We request the High Court to decide the appeal as expeditiously as possible, and in any case within a period of 1 year from today.
6 months.
6 months.
Yeah, my lords. Petitioner before my lords, but those people who were duly selected, my lord. And my lords, your lordship had issued notice that they are trained, they are all trained apprentices, my lords, and the untrained ones are working, my lord, and trained ones are all out. They work for about.
You are arguing which matter?
I beg to appeal from the railway lordship. In fact, this is second round of litigation. Already at first instance, this lordship, your lordship has already seen that we have complied with the order. There are 27th.
Who is with? That's what I was saying.
I'm so sorry.
I was wondering how do those apprentices and
Lord, one petition, my lord, which requires, because your lordships are dealing with the medical colleges on daily basis. I want to make a very humble submission in this matter before I come to that point which is to be raised. My lord, the statutory authority must inform your lordship, my lord, that the regulations for standards, my lord, are of 2020. They wanted to upgrade it. My lord, the issue here is, there is a minimum requirement of regulation 2020. The NMC wanted to upgrade it. There was not an agreement within the NMC, and what I am saying is from the central government order. So, 2023 regulation never came into force. Now, but today what is happening is, and 2000.
Oh, but how can by an interim order 50 additional seats be there?
Submitting, interim order, what is very clear, I know something else. As per the 2020 norms, I am fully compliant. The learned single judge of the High Court record the submission and then Malad loses the track and says 2020 norms you don't fulfill. The norms of the central government has decided is that the MLC did not approve the 2023 regulation. They have not come into force. Therefore, we have to go back to 2020 and as per 2020 I am compliant. But please have a look at Malad these synopsis. Kindly come to the synopsis, Malad, page C.
Yes, but
If I am full, Malad, the only objection is that I have 18% efficiency, right?
how can by an interim order you when be granted 50 additional seats?
To be allowed on the first day. Kindly have a look only one. Malad, the NMC can't say wherever I wish to apply 2023, I will apply, I will not apply 2020. Please see C, page C. As per the Malad, the norms which are laid down as per 2020, the Malad minimum requirement of faculty is 54 in the first year. I am admittedly, when I am disputing the figure of inspection, my faculty is 90. I am fully compliant. They apply Malad 2023, which Malad the central government, Malad please see page D Malad, the central government order which is quoted in para 6, I want to read the quoted portion. The committee also observed, this is Malad the central government second appeal. The committee also observed that the instant case was rejected on the basis of non-compliance of UGMSR 2023 and guidelines run under that. Meanwhile, NMC, while a letter dated 23/8/24 informed to Ministry that UGMSR Regulation 23 notified on 2nd June and guidelines frame under Regulation notified on 16/8/23 which is applied have not been approved by the Commission. Hence, the legal validity of Regulation 23 guideline is not clear and they granted the relief to that college on the basis of 2020. But not the learned single judge records it. Kindly come to Malad page Malad, the learned single judge, please page C 328. 328. And this is happening in most of the colleges wherever the permission is to be granted, they follow 2020, wherever they want to stop it 2023. Kindly see last line. Last sentence, not 4 lines from bottom. Further, it was contended.
326.
328, Malad, I'm so sorry. 328, last 4 lines. Further, I'm sorry, Malad, 328, last 4 lines. The sentence is, further, it was contended that subsequently exercising the power conferred under so and so, respondent has framed the minimum requirement of 2020, which was my case. Published in the official gazette also, the said regulations are applicable from the academic year 21-22 onward. And kindly see what is applied in para 21. Moreover, the argument made for the regulation of 2023 that it is not applicable are not tenable as there is it categorically spelled out certain deficiencies including the manpower cannot be cured at subsequent stage. Moreover, the regulation 23 have a statutory applicability. It is not even approved. They are not even regulation. And I am fully compliant. And Malad, one more. Yes, Malad, and something more, Malad, one more aspect which I want to say. Malad, in so far as gynecology department number of delivery, there is no norm. Your Lordship decided, Justice Sikri decided a matter here, there is no norm. So, Malad, the college is improved. In my case, Malad, after I have shown, Malad, please come to page, Malad, kindly come to page, Malad, page E, if the list of dates. Counseling extended to 5th December by the Government of India. Because the number of colleges have been given increase.
The present petition, paragraph. We have a request the division bench of the High Court to take up the appeal for hearing expeditiously.
I am deeply annoyed. Otherwise, Malad, I have bothered your Lordship that please ask them to put every order we used to be done. But all inspection, all orders, all consideration were being put on the website, now they are not putting it, because somewhere they want to apply 20, somewhere they want to apply 20.
We'll do it in an appropriate
Yes,
stage.
but I'll do grateful to you.
I'm sorry, there was a group. This is a writ petition, madam, on 32. Your Lordship had issued notice, madam, in this case, what has happened, madam, the trained apprentices who were appointed and who worked for more than 10 years, my lords. They were thrown out of service, my lords, and the untrained ones are working. If my lord will permit me,
And file your reply.
Lordship, we have filed out, your Lordship has directed us to file one additional document wherein we have already formulated one principle with regard to giving preference to these trained apprentices. In fact, already the prior litigation, this is the second round of litigation, they were party to on SLP. When your Lordship being passed, that time also that direction, that been complied. The Lordship being satisfied at page 205, that has been recorded adequately. That those, and this relaxation of age been also granted to them, if in any case they are going to apply and consider for that particular post. So already policy is there, your Lordship.
They are all important.
Their prayer primarily is only with regard to failure of policy. You will see their prayer, your Lordship. Page 8. Sorry, I'm so sorry.
They have worked for 10 years, they are all more than 45 years of age, my lord. And your Lordship, they have vacancies. If your Lordship may direct them to find out the vacancy, where we are just 606 total, my lord.
That is
370 have already worked, my lord, for 10 years. And 236 were remaining who had to join. So if your Lordship, if they can accommodate, my lord.
How can we?
Madam, kindly see, there is no dispute that they were selected through a selection process. Their qualification.
They selected through selection process.
Page 205, your Lordship, may come last 5 lines, 4 lines, Lordship, of your Lordship's order. That has already been considered by the judge. Page 205. Last 5-6 lines, your Lordship. May I read it?
Yes.
He now submits that his clients have served for more than 10 years are not in position to appear in the test. We are concerned with a large number of applicants in this case. Process of selection is still on. We direct the railways to give relaxation of age to the applicants by deducting the period of services for which they have worked. They may also be considered at par with original applicants by allowing them to take part in selection process. That has already been done.
But in that case, were they recruited after a selection?
What had happened, Your Lordship, there are two aspects being there. One, OA being filed by trained apprentice, one filed by untrained one. Now they allowed striking down our previous policy wherein we were giving preference to the trained apprentice. Then subsequently, 2016, again we framed the guidelines, which they are seeking now. We are at page 39, the prayer. So we have already filed the guidelines, Your Lordship, also.
No, whether the employees in this, that Abdul Hamid.
They're 97, Your Lordship.
Yes, but were they also the persons who had come through a selection process?
Indeed, Your Lordship. And that's why they have not selected, because all others being selected, they didn't get selected.
In view of this judgment?
Well, this judgment stands against me, my lord. But Your Lordship, at the time of issuance of notice, madam, there are only 606 people. By this judgment, what has happened? What has happened is, my lord, that
we can't pass any contradictory judgment.
I'm only submitting this, my lord. 606 all trained apprentices, my lord. None of the trained
If some judgment is passed by this court in a similarly circumstanced case,
What I was saying was,
Referring to a larger.
the basis of equity. No,
They were party principal.
If
They
today, only one prayer if I can.
Thank you.
Maharaj, only one prayer if I can make. I'm sorry, Maharaj. They have more than.
We can't permit backdoor entry.
We were selected through a new selection process, Maharaj.
Similarly, circumstances persons, the order is passed by this court.
For them only, Lordship. They were
They were parties to
They were
that.
party, they filed impeachment, they were party there. This is what I'm saying.
Then how can we?
Very parties. Today we are all over age, Maharaj.
Very parties in that.
We had filed an impeachment application.
Thank you.
If they can give some age relaxation.
That is already given by that order.
That order.
Thank you. We can't travel beyond that order.
And there is 28.1.
I've been also said petition. It said 2 months. Review was modified on merits. Therefore, all fabricated documents, the government has found that what is plastic structure again. So at least it should be heard on merits and matters should be remanded. It records.
In 28.
Yes. Running. Para 5. The last 2 lines, the review application was dismissed from merits. So it must be in the final order on 2023. And this letter patent appeal was filed on 25. 1 month limitation in any case are there and 10 days to procure the order. So hardly 20 days delay was there.
No, review was dismissed. If it is reversed, I can understand, merger.
Review was dismissed from merits with certain modification.
Modification.
Yeah, that is what it says on merits. So I will release it back so that we can place all these factors and page 35.
28.1.
Is my challenge to contempt. I was not a part in the main petition. I have nothing to do with the matter about that. And the delay. I also state the contempt.
From January, filed in March.
Yes.
I appear for the lecturer concerned, Gauri Jelani. The order which allowed her to for her regularization was passed on 9 June 2020.
But where is the delay?
Your Lordship, thereafter the review was only filed on 3/12/2022.
No, Ms. Ansuya, it was dismissed on merits in January and the LPS filed in March.
Your Lordship, the review was dismissed. There was only one modification which said that this shall not be treated as a precedent. That was the only modification, Your Lordships. There was no change. And only thereafter, after 2 months of that, the appeal was filed. Nothing stopped the concerned parties from filing an appeal directly. They went in review. The only change that was made was a one-line change, which said that this matter shall not be treated as a precedent.
See page 35 also. Forgery, fabrication of.
I'll place the review order.
Page 35 and 28. The governor's report by appointing a screening committee immediately after the order. And then all these were recorded. This is 23 March 22/3/2023. Immediately after the third paragraph. Page number 35 in item 28. Not only this, it is also a case of misrepresentation of material fact as well as the fabrication of documents which contradicts each other, which is evident from the date of interview. She was interviewed before the advertisement. Anyway, that appeared deal in the High Court.
That advertisement was not pertaining to her. There is no advertisement as far as she is concerned. Under the statute, she could not be regularized.
Your Lordship, I may place the review order. That's at page 96.
Well, let it be decided on merits. The petition challenges the order dated 8/10th of August 2023. by which the appeal of the present opponent was dismissed on the ground of delay. We have heard Raju the learned ALG and
the contempt, not with the others.
Think the learned senior counsel on behalf of the petition and Srimati also the learned counsel for the respondent. We find that after the order was passed by the learned single judge, the review application was filed on 3rd of December 2022. The review application was filed he says after 22 months.
Yes, Your Lordship. It was filed on 3/12/2022 and the order of the single judge is 9/2/2021. And in this period,
they condoned in the review.
So in the review application, there was a delay. The same was condoned and heard on merits. Ultimately, the review application was dismissed on 20th of January 2023, and the LP was filed on 25th of March 2023. Also, it cannot be therefore said that there was an inordinate delay in filing an appeal. We therefore set aside the impugned order, remit back the matter to the High Court for deciding it afresh in accordance with law. We set aside the impugned order. The delay in filing an appeal is condoned. The appeal is directed to the Court of Merits.
The contempt matter I was not originally implicated. Subsequently, I was made a party. I have nothing. The order is not passed. I was not a party in the matter. Or I have nothing to do with the either regularization or paying him the salary. But now, in view of the fact that the matter is going to be considered on merits, there is a question of contempt.
There is no order.
Since this must be seeking contempt of the single judge's order.
Yes,
So contempt of the single judge's order, because the single judge's order had to be performed within 4 months. And thereafter, instead of performing the order, they just had one opinion committee after another.
No directions issued to me. I am not a party.
Petition challenges. The order dated 15th of September 2023. By which the notice was issued to the petitioner. We submitted that the petitioner was not a party respondent in the writ petition, and no directions were issued to him. In any case, in view of our orders passed in SLP number so and so, the appeal challenging the order of the learned single judge is restored and will have to be decided on merits. Was he a party too?
The OST judicial was a party.
Was the judicial?
Yes. He filed an affidavit whereby he said that I have complied with the order to the limit extent possible. And
the contempt, not in the main of it.
It's the contempt matter. Therefore, either this is the vice chancellor is actually the authority to decide everything. He was included. The OST judicial, either the OST judicial or the petitioner has to be included.
It's far as the present petition is concerned, since the petitioner was not a party to the writ proceedings and no directions were issued to it, we set aside the part of the impugned order which issues notice to the present petition.
Yes,
Right.
My lord,
I appear for the petitioner, my lord. This similar order allowing the SLP is at Annexure P2. This SLP arises out of an order issuing contempt notice and framing charges for compliance of an ad interim order, my lord.
Yes, that Allahabad.
Allahabad.
Where is that order we passed in? Mr. Parmeshwar had appeared.
Beg your pardon?
Mr. Parmeshwar had appeared. Where is the order passed in the similar matter?
My lord, Annexure P2, page 22. It's a 3-judge bench order, my lords. Legal remedy was directed to be sought with regard to vacation of interim order. That was sought, but by the time, but the contempt was initiated, so the orders were set aside. Here also, my lord, we have sought vacation of the interim order. It is also
covered. We have also passed similar orders in Mr. Parmeshwar. In one matter, Mr. Parmeshwar had appeared. In one matter, Ms. Bhatti had appeared.
The circumstances are exactly covered by PO, as my lord pleases.
Your Lordship, kindly see this matter is fully covered by, passed by Your Lordship order. Kindly see Your Lordship page 100 and page 101.
By Your Lordship's order, he becomes disentitled. He's claiming to salary of a trained teacher. The delayed degree, he has delayed certificate he is obtained after the cutoff date Your Lordship has stated. And page 53, my lords. Page 59.
Where?
Please, Your Lordship, kindly see 101, Your Lordship.
Page 59 is Your Lordship file.
And thereafter, Your Lordship, Honorable High Court has issued notice. Lordship, page 101 started SLP's number so and so, Jaivir Singh and other versus state of Uttarakhand. It has been held that the certificate of validity granted by National Institute
But
of...
on the facts, whether it is there, they have filed a vacate stay petition. In the meantime, you go and file a contempt, charges are framed. So the earlier order says
Question is, when Honorable High Court has issued notice and interim order has been passed, state has not complied, even state has not challenged that order, then Your Lordship contempt.
The petition challenges the order passed by the learned single judge. Dated
My lord, the impugned order is
20th March.
20th March, and the second impugned order is 30th April 24.
20th March 2024 and 30th of April 2024, by which the notice has been issued to the petition. No, full stop. By the first order, the notice is issued to the petitioner. And by the second order,
at page 4.
Ashoka's notice, a charge has been framed against the petitioner for committing contempt of the court. Paragraph. The contempt petition alleges non-compliance of the order dated 20th of December 2023. First, it is informed that state has already filed an application for vacating the said interim relief. Right.
That was filed on 19th March 24.
We therefore dispose of the present petition. We request the High Court to first decide the application for vacating interim relief filed by the state. Until then, the proceedings, contempt proceedings, are directed to be kept in abeyance.
I'm grateful. The charge order may need to be set aside, my lords.
We are kept in abeyance, so
Because at that juncture, so like in Annexure P2, Your Lordship directed, the order was set aside. So the contempt they can very well initiate also if it is not complied after the interim order is decided. Because charge order may not continue, my lord. Annexure P2, Lordship would have the operative portion. Page 23.
no, if you are interim order is vacated, then you can pray for dismissal of this proceeding itself.
They can, at least the charge order should.
We are directing everything to be kept in abeyance. Till the appeal is, your application is decided. It shall be disposed of.
This has been issued, Malad. The 5th of August, Malad, and I just want to point out, Malad, this is a matter in which, Malad, the Backward Commission, Malad, exercises powers of inclusion. And then, Malad, the executive exercises the powers of sub-classification, which your lordships have now held, Malad, in the constitutional judgment. Now, Malad, in this case, Malad, that's been struck down. Both have been struck down. And kindly have a look at this chart. I'll just give this to your lords.
Will have to be heard.
Now, except, Malad, we need an order to the effect, Malad, that just giving copies to it. Give it. Give to my lord. I will have a look at this list. Inclusions of 76 have been struck down. There are total 76. Now we have indicated here how the central list, Malad, includes them. We include them from the central list or from the Mandal Commission or from Hindu counterparts in SC, ST, OBC, and Malad, and from neighboring states, Malad. Therefore, Malad, the court says that we'll strike it down, despite the fact that it's in the central list in the neighboring state and the Hindu counterparts have been given this provision. Now, Malad, the result is educational institutions, people cannot be admitted, Malad. Recruitments can't take place. All OBCs have been, all OBC notifications have been struck down after 2010. Malad, how can this be?
And the reservations have been operating.
And all this has been struck down, Malad.
No, but all those who are in service, they have been protected.
Correct, but Malad, we can't do recruitments, educational institutions, caste certificates have to be given.
We'll hear it at the earliest.
Yes, sir. It's been pending since August, Malad. It's been pending.
We'll put it up to 2 weeks or so.
Look, the reservation has been operating for the last 10 years. I'm hearing
We'll hear it on merit.
No, that's wrong.
No, but now the commission has filed an affidavit.
Yes, commission has filed and explained.
You have much to say on that affidavit. Taking a stand that there was no survey done, but we did something. That kind of.
No, the survey was done. That's completely wrong.
How long it will take?
This is the problem, Malad. This is going to take some time. And in the meantime, Malad, the academic year will pass, Malad. And since August, Malad,
Several days, reports were looked at, we went and argued the matter. I reports one six up the page, the commission did a watch. Let them show.
Since 2010, all certificates have been struck down.
And you will also consider that.
If you are an OBC in the central, Malad, under central government, I can't be OBC there, Malad, in the state. Can it ever be upheld? And since 2010, all certificates struck down. Since 2010, 143 sub-classification struck down. And that sub-classification is the prerogative of the executive, Malad, struck down. Okay.
Prerogative, but then it has to be done.
After following, it was done.
We are let down that there is important data.
Kindly say, all recruitments, all prior recruitments.
We'll keep it for hearing.
All prior recruitments were done on the same basis. They didn't challenge it. Same basis. All recommendations made by commission. No, that's completely wrong. This is the point, Malad. At least some via media, till such time your lordships, Malad, here.
We'll consider on interim.
Yes, please.
Yes.
They have filed their affidavit also. Their affidavit also is there.
So far as stay is concerned, I have 3 points to make. Number one,
Mr. Amadi, even for a stay, it will require at least an hour.
That's correct. Can we have it
Today-
as soon as possible?
2010. They've been struck down thereafter. So, without follow, there was no stay.
Illegality,
Therefore, was all that I'm trying to say, for a balance of convenience, these persons were there on the center. These staffs were there on the center. We were on the neighborhoods. All that has been pointed out by the state and statute. On balance of convenience, I felt to be a lot of like to put it immediately.
Of course.
Yes, we will.
That's what my lord is saying. That's what my lord is saying.
That's what we are saying.
That's what my lord is saying. Yes, yes, yes. Can it be on a Friday at 2 or something, Mother, so that?
Friday, the difficulty is that we can sit on Monday, but not on Friday.
Monday?
Tuesday, Wednesday, Thursday, NMD.
Monday at 2 is possible.
Monday will.
Yes, Monday at 2.
Monday at 2.
And for the commission, I've been led by Mr. Dwivedi. We have filed an SLP, no notice has been issued.
Mr. Dwivedi is here.
Yes.
Yes, sir, notice may be issued.
I am appealing for this, some of the petitioners we have not heard at all.
30.7 may be notice may be issued on that.
No, at the moment, it's only on the stay, that's all.
9th December.
9 is 9.
9 December. Very grateful, man.
At 2 p.m. Mother?
At 2 p.m.
Keep you.
Very grateful. Very grateful.
Very well.
It looks.
Yes. Did you get instructions?
Please not. No, he's only the driver, he's not the owner of the bus, my lord, and he's a poor retired person, is a senior citizen. He's paying for 75,000.
Issue notice. Is it inside or is
Outside,
exemption?
exemption was given.
There was an exemption last week.
Issue notice written in 4 weeks. So, pehle leave to implement the legal heirs of the deceased. The issue notice. The amendment is carried out within 2 weeks. Issue notice returnable 3 weeks. Returnable 4 weeks. The exemption granted shall continue to operate on the condition that the petitioner deposits an amount of ₹75,000 within a period of 4 weeks. This
Deeply obliged.
Please, Lordships. Lordship, my LPA has never been considered on merit, Your Lordship.
No, he is not here.
I'm only pressing for remand, Your Lordship. The resolution.
Sounds stupid.
The resolution has been upheld by full bench of High Court, then the Supreme Court. And the LPA bench says that a supplementary affidavit was not filed properly, wrong
I
word.
will have it on Monday. He is not here.
Monday,
Monday.
please. Monday.